You want that finding as well?
That the court has
You
not
want that finding as well?
That the court has not gone in the prior user. Who is the prior user?
No. Why should I go into it? In section 482, who is the prior user or not the prior user? That issue is large pending. Why should I go into?
A copyright, when it is proponed or challenged, has to be duly established in a competent court.
Yes, there you are.
Specific provision. And just copyright subsists as soon as the work is created in a given material form, even if it is not registered. Thus, even if the plaintiff work was not registered, the plaintiff have established that it has created same prior to the defendant. I am going one step reverse here. Lordship, assuming that I don't have a registration, but I am prior user than the defendant, then also the criminal action lies, Lordship. Because here the copyright is to be seen who is the prior user of the artistic work.
But that is to be seen by the competent court, not the police.
Then I'm coming. That is clear that it is maintainable. Now I'll come whether the civil remedy and criminal both are maintainable. But mere registration by the defendant. Thus, even if a plaintiff work is not registered, the plaintiff having established that it has created the same prior to the defendant, mere registration by the defendant of its work cannot defeat the plaintiff claim. So even if it is registered, the plaintiff claim cannot be defeated. Moreover, in the present case, the plaintiff work is also registered under the copyright. The plaintiff work was registered prior to the registration of the defendant work. Mr. Kadam relied upon the opposite judgment of a Delhi High Court in support of his submission that in case where it is not possible to be defined as to who was the original creator, the extract contains the entry to the effect that the year of first publication was 1992. Year Lordship, I am using since 2000.
All right, madam, I am giving you two options: notice and stay, or rule or stay. Option is yours. Notice and stay, you will be having opportunity to file a reply. I'll say that, reserving all your right. Open. Rule and stay. Choice is yours.
If my lordship may be permitted, I have an option what not is coming from the option. But at least I may be permitted to explain.
Alright, you explain by your affidavit. That will be given to you.
But for an objecting for a stay.
Stay will be given to it. Or if you say I can by reason I can grant.
But now the charge should have already been filed. What
maybe
in the stay, lordship?
This is abuse of process of law, prima facie, according to me.
Because what will happen, lordship? If the honorable court will grant stay from here, the civil court will not grant me any.
No, that is not the way.
Because that will be influenced. This order.
No, I will say there is no offense at all.
No, but if
prima facie.
No, if the court comes to a conclusion.
Yes.
Just a second.
So that is the FIR and charge sheet is filed only with a view to see that civil court grants stay.
No, just a second.
It comes to that
No. If the court comes to a conclusion.
Civil court has ultimately different powers, and he is not bound by any findings of the criminal courts.
Lordship are aware what are findings, but Lordship, I don't want to indulge into all this.
That's all your creation, madam.
No, that is not my creation, Lordship. But once an High Court says that it is not an offence, there is no similarity between the mark.
No, I will not say no offence. I will say section 50 or what is that section? 51.
Only
prima facie does not attract.
Only last judgment, then I will select the option.
No.
Only last judgment, Lordship. Only last judgment of a Kerala.
Yes.
Lordship, only I am answering the query of the Lordship. Just a second.
Then
only
rule. All right.
It will come under the infringing of copy as defined under section 2M subclause 2 of the Act. The petitioner also could not produce any prima facie material to prove that they have got any permission or license to take copies or sell the copies of the work from the owner. So by taking in at section 44 and 45, the petitioner are not entitled to get the quashing of the proceeding.
Contrary here.
Yes, and reading the next one. It is relevant in context to quote Zahir Ahmed versus Ahmed Khan, wherein while dealing with section 63 of the Act, an infringement of copyright, it says that there is nothing to indicate under section 63 and 55 to make registration compulsory for availing the remedy provided under the section. It was held that the proprietor of an unregistered copyright can institute or prosecute a criminal prosecution under section 63 of the Act if it is infringed. It is also held that the registration of copyright is not mandatory and it is optional. So without any further discussion, it can be considered the relief sought by the petitioner to quash the proceeding pending against them in view of the fact that the alleged infringing copyright is not proved to be registered under the provision. The register of the copyright or the owner are arranged as witness is not system. But that's only my submission before this honorable.
Yes.
You should have incorporated charge sheet and what are the evidence?
First, explain me why 64 invoked.
Like in prohibition, even the seizure power is 98.
Seizure power is an offense.
No, it's not at all.
Has been invoked in FIR
Definitely not.
over Julius. Next.
That is it. It's not an offense.
Non-application of mine.
There is also recent judgment that copyright is a cognizable offense by justice.
All right. All right.
Lordship, for that what I'm saying that initially
I don't say that it is not a cognizable offense. I don't say that.
That's true. But
With respect,
what
applicable.
just
With all respect.
because only thing is that my lordships, the reason is this, right? Because how then the true owners are protected? The
Draft
reason
amendment.
is, lordship, for an example, just for an example, out of this pattern, lordship, there is a logo of Tata Reliance. Behind the back, if I go and apply, is it that I am permissible to use the logo of Tata and Reliance?
Maybe not, but not an offense.
It's an offense under the Copyright Act, lordship.
All right. We'll decide it.
Ms. Rushvi Shah.
Ms. Shah, the learned advocate, has vehemently opposed the present application by relying upon. Should I refer all judgments?
Yes, yes. And section 44, 45, 51, and lordship can refer to the products also because I have made.
It is heavily relied upon.
that you are using
Vehemently opposed the
different
present
methods.
application by referring to various sections such as section
45,
45,
44, sorry,
44,
45,
45,
51,
51,
63, and 64.
63 and 64. Further, this court would note the fact that invocation of section 64 by the police in the FIR is nothing but a sheer non-application of mind by the police. Rule waived by Ms. Shah, service of rule waived by the AP Convention.
Lordship, may I request this wise, that this may not influence the civil court to make
No.
an independent.
No, I will not.
Lordship, but at least court can say that the
Yes,
court
next
has,
matter.
just a second, Lordship.
I said prima facie.
No, Lordship, what I am saying that court is not.
That is my option given to you, madam.
No, Lordship, I am saying other request, at least Lordship
Oh.
here.
No,
Lordship, I am
matter
saying
is
that
over.
court has not decided who is tire user.
Why should I decide?
That is not been
If
decided.
you want that finding as well,
That the court has
you
not
want
gone
that
because-
finding as well.
That the court has not gone in the tire user. Who is
No.
the tire user?
No. Why should I go into it? In section 482, who is the prior user or not the prior user? There is large. That issue is large pending.
Not gone into.
That why should I gone into? I have not gone into. I have not said so. If I have gone into, I have observed that. Simple is that. I have not said that issue.
Okay.